This matter is before the court for Zoom pretrial conference subject to mediation. The parties are present, as well as Attorney Kirsty Nemec representing the plaintiff, Jill Calktons. Ms. Nemec indicated that the parties were not able to reach their own resolution this morning. Is that correct?
That is correct.
Okay, Ms. Nemec, the court's going to complete a pretrial statement. What do you see as the issues? And I'll confirm these with Mr. Calktons. Is custody and parenting time an issue?
It is, Your Honor.
Okay. Spousal support, is that an issue?
I would like to leave it open. I don't know if ultimately it will be an issue.
Okay. There's real estate to be divided, is that correct?
Correct.
Property, retirement benefits.
Yes.
Okay. Is there significant unsecured debt that needs to be addressed?
Yes, there is.
Okay, so a lot of issues on the table. With respect to the real properties, is it just a marital home or is there other real estate?
There is other real estate. The parties also own two other commercial buildings.
Okay. So we need appraisals.
I think at this point, the one thing we were able to agree on is that the parties will try to reach out to realtors to get comparative market analysis for each of these, or for two of the properties. One property is probably not going to be an issue, but we would be looking at a CMA for the home in Carlton and a CMA for the office building in Wayne.
Okay. So you said there's 3 parcels.
Yes, the other one is right downtown.
Okay. So the marital home plus 2 commercial.
Matt, why are we not getting a market analysis on all 3?
Because your proposal was to quiet title on the third one and split whatever proceeds.
And that's acceptable?
At this juncture, yes, but if you feel that we would want to just do a CMA on all 3.
No, if that's an acceptable resolution to that, we can go ahead and eliminate that as an issue.
Well, I'm just marking as potential issues, Mr. Calktons, but absolutely to avoid the cost associated with an appraisal, secure fair market analysis of all parcels, each of you independently, and then compare. And maybe you can find some middle ground before we incur that expense. So obviously further discovery is necessary, so the court will keep discovery open. The court will simply order that if an appraisal is necessary to secure that as soon as possible. So we need to move on those fair market analysis because those should be secured within, I would think, within 30 days. And then if the parties cannot reach agreement as to current fair market value of those parcels, then appraisals should be secured. This matter has been pending for 3 months. There's been no motions filed for temporary relief. Obviously, the parties right now are they still living together, Ms. Nemec, or are they separated?
They are not living together, and I will be filing a motion after this mediation.
Okay. Were the parties able to talk about even some temporary parenting time?
The parties had worked out prior to this mediation. They were trying to work out an agreement regarding parenting time. However, there have been some issues that have arisen during that trial period, which has caused them to disagree as to how custody and parenting time should be going forward, which is why we will be filing a motion.
And Your Honor, if I may speak on that just briefly, the parties, my wife and I have been exercising since late July or early August a parent time schedule as such: Sunday, Monday, Tuesday overnights with me, along with every other Friday, Wednesday, Thursday, Saturday overnights with her, along with every other Friday. This has gone as recently as 3 of the past 4 days with me. I just want this to continue until some other motion or order is filed. I don't want things to immediately stop absent some order of the court. So can I have that instruction, please?
All right. Again, obviously, there's no orders in place, and obviously, if the matter came before the court to address that, the court would look at what the parties exercised, and if it's worked out, unless there's been issues with the past schedule that's been exercised by the parties. Court would certainly look at that if it's been exercised since July, but that will be addressed at a later date. It's unfortunate the parties can at least put that agreement on the record today. The court would encourage them to continue what they've been doing, but the court cannot order that at this point in time. And Ms. Nimick, how long have the parties been separated? Can you give me a month, a year?
Jill, when did Jared leave the home?
July 19th.
Okay, so July of 2024. Okay. All right, so the court will leave discovery open. Have the parties exchanged the verified financial affidavits, Ms. Nimick?
Yes, they have.
Okay, and Mr. Cox has received Jill's. Okay. Is there any discussion about a future mediation with a private mediator such as a Godfrey?
I don't think
that would-
Mr. Godfrey would be able to mediate in this instance due to his prior representation of Mr. Calktons. I think
At least make inquiry. If Ms. Calktons agree with that. And interesting, and you know Attorney Paul Longton?
Oh,
I'm familiar with his name. I've not worked with him in the past.
Well, he's probably in his early 70s, mid 70s, a rare practitioner, and he wanted to mediate a case with Godfrey. And he said, Godfrey represented my wife in the divorce, and I was so impressed with him that he's comfortable with Godfrey calling like he can see, like he sees it. So you may want to ask if the parties are comfortable with that. That's a prospect. I think Godfrey has a great reputation of sort of helping the parties reach their own agreement. He's very successful, even though he maybe knows both parties. But I'll leave that to you.
If the
So there's
parties
no
are
continued
agreeable,
mediations.
I'm sorry, Your Honor. If the parties
Go
are
ahead.
agreeable, I'll reach out to Mr. Godfrey right after mediation. You guys
Okay.
don't have to answer right now. Just send me an email and let me know.
I'll put on the record, I'm agreeable to that.
I'm sorry,
And
you said
maybe-
you,
I'm
Yeah.
agreeable to that, yes.
and then Jill, you and I will discuss it after.
Okay, and I think Godfrey right now is scheduling right now into February. But again, you can maybe at least make that inquiry, Ms. Nimick. Mr. Godfrey may say he doesn't want to, but again, you can at least make that inquiry. But there's no future mediation schedule with Ms. Pratt, is that correct?
That is correct.
What the court's going to suggest is, since we still have discovery outstanding, is that the court could take the proofs this morning and they'll stop the court's clock. And the court will reserve all outstanding issues and set this for another pretrial conference whenever you suggest, whether it's in December. At least the court we can update things at that time. And let the parties exhaust a complete discovery and exhaust all efforts at ample resolution before the court schedules a evidentiary hearing. Is that agreeable, Mr.
Yes, Your Honor.
Calktons, Ms. Nimick? All right.
It is, but December may be a bit short if Mr. Godfrey and some other mediators are set out till after the new year.
Right, but at least then you could tell me in December that we've got a mediation date, just so I know it's moving along.
Very good.
All right, Mr. Calktons, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Yes.
Thank you. All right, Ms. Nimick, if you can begin with Ms. Calktons, please.
Jill, I know I didn't prep you for this. We're just going to take the jurisdictional proofs to show the court that it has jurisdiction to have this case, okay? So could you state your name for the record?
Jill Renee Calktons.
At the time that you filed your complaint for divorce, had you lived in the state of Michigan for at least 180 days?
Yes.
Had you also lived in the county of Monroe at that time for at least 10 days?
Yes.
There are 3 children born to this marriage, correct? Isaac, who is 11, Elizabeth, who is 9, and Lucas, who is 7.
Correct.
Okay. And you were married August 23rd, 2003 in Monroe County.
Yes.
Okay. Are you currently pregnant?
No.
And are you stating to the court that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
That's correct.
I have nothing further, Your Honor.
Thank you, Ms. Nimick. Mr. Calktons, can you please state your name and mailing address for the court?
My name is Jared Calktons, and currently I am using 907 Fix Road, Monroe, Michigan, 48162.
907 Dix Road, DIX.
F-I-X.
Thank you. And I'm sorry, is that Carlton or Monroe?
That is Monroe, 48162.
Thank you. Mr. Calktons, did you hear the testimony this morning of your wife, Jill?
I have.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Ms. Nimick, do you have any questions of Mr. Calktons?
I do not.
Very well, based upon the testimony that's been presented this morning, as well as complaint filed this matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears at this point to be no reasonable chance of reconciliation. At this point in time, the court will simply reserve all outstanding issues. Schedule us for a continued pretrial conference. The court will mail out notice to the parties.
Your Honor, if I may, I have a couple of requests that would deal with discovery.
Go ahead, Mr. Calktons. Court's leaving it open.
Right. But as the court's well aware, I'm no longer a licensed attorney, but I do have multiple years of practice and knowledge in the field. Part of discovery that's going to be required are requests for productions, requests to admit, interrogatories, as well as possible depositions and possible subpoenas. The normal course, and I think we should still follow this for subpoenas, is that a non-legal, non-lawyer would present that subpoena to the court for signature. But as far as the request to produce, request to admit, interrogatories, and depositions, I asked the court to allow me to be able to sign those and send those along with the applicable proofs of service without bothering the court for such issues.
I don't see any reason why not. Obviously, you can certainly represent yourself, Mr. Calktons, and you can certainly submit interrogatories. Ms. Nimick, do you have any problem with responding to Mr. Calktons' request for discovery?
Absolutely not, Your Honor.
Thank you.
Unless it's a subpoena to a third party. If you want sometimes the clerk signs those subpoenas, but perhaps Ms. Nimick would cooperate in securing the presence of that witness.
It would not be for witnesses at this point, Your Honor. It would be for documentation, but I will, I'll sign any subpoenas directly to Ms. Nimick and Mrs. Calktons. As far as third parties, I'll bring them to the court or the clerk. Okay,
certainly just a request for production of documents. In fact, if that's not, they don't respond to that, Mr. Calktons, you can always then secure a subpoena, but hopefully that will not be necessary. I think Ms. Nimick is known for working with parties represented or unrepresented. Okay, so let's schedule another pretrial conference. Court suggesting some Friday in December. Just to the parties give the court an update.
Your Honor, I would be out from the 20th forward. So would the 13th be available?
Good. Ms. Nimick, you had reached out to my clerk, Ms. Andrea, for a motion hearing date. What date?
She gave me two options, November 20th or November 26th. I was just kind of looking at that out of my other eye. November 26th would work. 11:15 or 10:30.
Which one? How about 10:30 on November 26th? And we do a pretrial at the same time. Makes sense?
Yes, that does.
That's fine.
Right, so Ms. Andrea will secure your motion hearing date, November 26th at 10:30. Mr. Cox, you make note of that. The court mailed a notice of a continued pretrial conference, November 26th at 10:30 via Zoom. Will that work with Ms. Calktons with your schedule?
Jill, does that work for you?
I am looking at it right now. I'm currently scheduled to work, but I can modify that.
Okay.
And it should take hopefully maybe the parties can reach their own resolution and at that time, and the pretrial can be real quick just to find out the status of the matter. Right, so this matter is continued to November 26th at 10:30 for a continued pretrial conference. Anything further this morning, Ms. Nimick or Mr. Calktons?
Nothing further, thank you.
All right, and obviously, Mr. Calktons, you're well aware, and I'm certainly Ms. Nimick is the best resolution is one which the two of you, Ms. Calktons, participate in, reach your own agreement, as opposed to the court make a decision, because when we have a trial, a lot of assets will simply be liquidated, a lot easier to divide cash.
Right.
And obviously, you know what's best for your respective schedules and that of your children, far better off than anyone in this world, including the court. So the court would encourage you to continue some constructive discussion to reach your own agreement. And in terms of custody and parenting time, we're simply all this court is concerned about is legal custody. There's no, unless I'm convinced of reason, there's no reason why two of you should not be able to share joint legal custody. The court does not address physical custody, simply legal custody and parenting time.
I
And
think
of
we have
course,
agreement
school.
for legal custody, if I'm not mistaken. I thought that's what the agreement was in mediation. Am I incorrect,
Okay.
Ms. Neiman?
We didn't really have any agreements coming out of mediation other than to get a realtor and do CMAs. Tentatively, I don't think that we have an objection temporarily to joint legal custody, parenting time, and physical custody as it relates to parenting time is the issue.
Okay. All right, so I'm just making my this court's position known, Mr. and Mrs. Calktons. I don't think parents should get hung up on this title of physical custody. It's just a bit, who'll be the primary parent for school choice, namely, and obviously the oldest is in school right now, correct?
All three.
The airports, all private school districts. So obviously that needs to be addressed in any ultimate judgment divorce in terms of whose residence will determine the school of the children. So we're not coming back and arguing about that in future years. So it's primarily about parenting time. So hopefully the parties can continue to discuss between themselves, work out a good parenting time schedule. All right, with that, that will conclude this matter. We can zoom out. Have a good rest of the morning.
Thank you, Your Honor.
You're welcome.